ID, if your sheriff, your state police, or a border state still uses delay, guesswork, or vague words to block you, you could lose your rights without even realizing it. Quick question before we continue. Are you subscribed? Because what I'm about to break down could keep you from making a mistake that follows you for years. Hit that button now, because gun law moves fast, and the people who wait usually learn the hard way. Here's what just happened and why this matters so much. A few years ago, the Supreme Court said something huge in the Bruin decision. In plain English, the court said the Second Amendment protects your right to carry a handgun in public for self-defense, not just in your house, not just on your land, in public. And the court also said states cannot force regular law-abiding people to prove some special reason before they can carry. That matters because for years, some places used systems that looked legal on paper but worked like a trap in real life. You'd fill out the forms, pay the fees, take the class, wait for the interview. Then some official could still say, you didn't show enough need, or we're not convinced, or you're not suitable. That sounds official. But in real life, it often meant one thing. A government employee could say no because they felt like it. And the Supreme Court pushed back on that. The court basically said, your right is not supposed to depend on whether a local official likes your reason. That is the heart of this whole fight. Not whether states can have any permit rules at all. They can. The court made that clear. States can still use what are called objective rules. That means clear rules. Things like age limits, background checks, training, fingerprints, and disqualifying criminal history. You either meet the rule or you don't. But here's the crazy part. A lot of officials heard that ruling and still tried to keep the old game alive. They stopped saying proper cause out loud, but they kept using delay, vague standards, and extra hoops to get almost the same result. In other words, they changed the label but kept the system. Think about it like this. Most people think a denial is only a denial when you get a letter that says denied. But the truth is, a 2-year wait can act like a denial. A demand for a vague character judgment can act like a denial. A rule that changes from one clerk to the next can act like a denial. If the system lets the government stall you, scare you, or guess about your future behavior, it starts looking less like a fair process, and more like a wall. Have you ever wondered why so many gun law fights now focus on words like objective and subjective? This is why. Objective means the rule is clear. Subjective means some official gets to use personal judgment. And once personal judgment gets too loose, rights turn into favors. Now, this is where it gets interesting. The big shift is not just that the court spoke. It's that more people inside government are now openly saying arbitrary denials are a problem. Not just gun groups, not just lawyers on YouTube. The Department of Justice has started stepping into cases and saying delays and vague standards can violate the Constitution. And some states are backing court challenges too. That is a major change. Because when the federal government and multiple states start saying, I know you cannot play games with a constitutional right, local agencies suddenly have a much harder time pretending nothing changed. If you're finding this helpful, imagine what you'll learn in my next video about the exact words you should and should not say. When police ask about a firearm during a stop, subscribe so you don't miss it. Because knowing the law is good, but knowing how it plays out in real life is even better. Let me break down the first real-world example, because this is the part that shocked me. The Department of Justice filed what it called its first affirmative lawsuit. The lawsuit was in support of gun owners over concealed carry permits in Los Angeles County. That matters all by itself, but the facts matter even more. According to DOJ, after complaints came in, it looked at data and documents tied to more than 8,000 concealed carry applications, and the picture it described was ugly. DOJ said Los Angeles County had only approved 2 applications out of more than 8,000 in the period it reviewed. 2, not 200. 2. It also said applicants were being scheduled for interviews as far as 2 years after completing the application. Stop and think about that. Imagine you live in a high crime area. Imagine you did the paperwork. Imagine you paid the fees. Imagine you followed every rule. And then your interview gets pushed so far out that your right becomes meaningless in the time you actually need it. Most people would call that a delay. But let's be honest. For many people, that delay works like a denial. And that is exactly why this story matters outside California. Because delay is one of the easiest ways to avoid saying no while still blocking people. Officials can always say, we're processing. They can always say, we're backed up. They can always say, we need more review. But if the clock keeps moving and your application goes nowhere, your rights are still frozen. Here's a hypothetical example to explain this. And let's say you apply in June. You complete your training in July. You submit fingerprints in August. Then nothing. Months go by. You call in here, still pending. A year later, still pending. During that time, you avoid carrying because you don't want criminal charges. That means the system did not have to deny you on paper. It already got the result it wanted. Now, a quick legal note. This is educational information, not legal advice. Always consult an attorney for your specific situation. And Los Angeles is not the only place where this issue is showing up. DOJ also sued the Virgin Islands Police Department over what it described as unconstitutional delays and conditions on gun permits. The department said applicants complained about slow decisions, extra conditions like bolted-in gun safes before a license would issue, and even home search type requirements. DOJ also said the territory was still enforcing a proper cause style rule that looked a lot like the kind of rule the Supreme Court already struck down. Let me explain why that matters. A right can be blocked in more than one way. You can block it with a direct no. You can block it with a made-up standard. You can block it with cost. You can block it with fear. You can block it with delay. And you can block it by piling on requirements that ordinary people did not see coming. Most people think, well, if I'm law-abiding, I'll be fine. I wish it were that simple. But the truth is, many legal problems begin long before a person breaks a law on purpose. They start when a person assumes the process is fair, predictable, and fast. In some places, it may be. In others, not even close. So, what's the lesson here? First, do not confuse a silent application with a healthy application. Second, do not assume delay is normal just because officials call it normal. Third, do not assume every extra requirement is automatically lawful. Some may be, some may not be. And that line is exactly what the current court fights are about. Hey, 73% of people watching right now still aren't subscribed. Don't be part of that group. Join the people who come here to get straight, simple gun law updates without the fluff. Click subscribe, because the next legal change could affect your carry rights long before local officials bother to explain it. But wait, there's something even more important, and this is the part nobody's talking about enough. Even if your home state treats you fairly, another state can still turn your normal behavior into a legal nightmare. That's where the state-backed court fight comes in. A case out of Massachusetts drew support from New Hampshire and 24 other states. Those states filed a brief backing a challenge to Massachusetts' non-resident licensing system. Their argument was simple but powerful. They said Massachusetts was using a system that looked shall issue on the outside, but still smuggled in discretion through a word like suitability. That word sounds harmless. It sounds like common sense. But in practice, vague words like that can become a giant opening for arbitrary decisions. Suitable according to who? Based on what facts? Using what timeline? Measured against what standard? If nobody can answer those questions clearly, then you don't really have an objective rule. You have a guess wrapped in legal language. And the states backing that case argued exactly that. They said the system forced officials to judge whether information was credible, whether behavior was relevant, and whether that behavior suggested the person might pose a risk sometime in the future. Read that again in normal English. The government gets to guess what you might do later. That is a dangerous place for any constitutional right to live. Now, this is where it gets really serious for regular people. The states argued that this kind of system can turn a simple trip across a border into a felony risk for a law-abiding traveler. Imagine you live in one state, you have a valid permit there, and you drive into another state thinking you're still being careful. But that other state does not honor your permit, charges high fees, makes you apply under a separate system, and then uses vague standards to keep the door shut anyway. Most people think, if I'm legal at home, I'm probably fine next door. That is one of the biggest mistakes gun owners make. Do not make it. State lines matter. Reciprocity matters. Local rules matter. Non-resident rules matter. Storage rules matter. And if you guess wrong, the consequences are not small. Here's what most people get wrong. They hear about a major Supreme Court case and assume the issue is settled everywhere. It is not. A Supreme Court ruling can set the rule, but lower courts, local agencies, and state lawmakers still fight over what that rule means in daily life. That is why you keep seeing new lawsuits, new briefs, and new court battles. The main principle may be set, but the cleanup fight is still happening. So what should you do right now? First, know whether your state is truly objective or just sounds objective. Second, if you apply for a permit, document everything. Save emails, save dates, save receipts, save notices. Third, never assume silence means safety. If an agency blows past legal timelines, talk to a lawyer in your state. Fourth, if you travel, check the destination state every single time, not once a year, every trip. Fifth, if a denial uses vague language, do not just shrug and walk away. Vague wording may matter a lot. And let me say one more thing. This is not only about carrying, it is about how government treats rights in general. A right that depends on delay, cost, and personal guesswork starts acting less like a right and more like a permission slip. That should bother you no matter where you stand politically. Laws change fast. Court rulings move fast. Agency behavior can change fast too. Subscribe now because my next video breaks down the warning signs that a permit process is becoming an unconstitutional stall tactic. And I want you to catch that before it catches you. So here's the bottom line. The Supreme Court made clear that government cannot treat your right to bear arms like a special favor for a chosen few. And now you're seeing that principle pushed harder in real life, with DOJ lawsuits over delays and restrictions, and with multiple states backing challenges to vague licensing standards that invite arbitrary denials. If this video helped you see the danger before it becomes your problem, hit subscribe and stay with this channel. I make these videos for one reason, so good people do not get blindsided by confusing gun laws and life-changing mistakes. And one last simple reminder. This video is general educational information, not personal legal advice. Gun laws are different from place to place, so always check your local rules and talk to a qualified attorney about your specific situation.